90.3 WHPC now presents Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now, learn about the law and how to protect yourself against the loss of your liberty or property, and learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is attorney Kenneth J. Landau, a past dean of the Nassau Academy of Law, and frequently lectures to lawyers on ethics and avoiding problems with clients, and to the public on how to choose and use lawyers. This is Law You Should Know on the voice of Nassau Community College, 90.3 WHPC.
Hi, this is Ken Landau, and welcome to Law You Should Know. Today we're going to talk about the new Good Cause Eviction Law in New York State, which primarily applies to New York City, and our special guest is tenant and landlord attorney Linda Rzesniowiecki, and she's a very experienced and knowledgeable attorney in the city who generally represents tenants and sometimes small landlords who own under 10 units. Linda, welcome back to Law You Should Know.
Thank you, Ken Landau. Always a pleasure to be on Law You Should Know.
I know there's something new and exciting happening, the Good Cause Eviction Law, which has recently gone into effect in New York City and can be used. The protections in the law can be used on behalf of tenants who are in market rate apartments. So just tell us about the background and the reasoning for the Good Cause Eviction Law.
Well, tenants have been going up to Albany to ask for the Good Cause Eviction Law for a long time, and finally they got something. But what tenants got, is a little bit less than what they wanted in terms of protections, but it's something. The law passed on April 20th, 2024. It's effective as of now. The Good Cause Eviction Law, which we are calling the GCE law, it limits rent increases when a lease is renewed, and it prohibits landlords from evicting tenants unless the owner has good cause.
So in terms of the initial rent, the sky is the limit and market rate controls?
Yeah, market rate controls. And when a landlord offers a renewal lease, the landlord can only increase the rent by 10% or by 5% plus, quote, the annual change in the consumer price index, unquote.
Okay.
Now, what the heck does that mean? What is the annual change in the consumer price index? We don't really know at the present time. The New York State Division of Housing and Community Renewal will be defining this term in the coming months.
And is the tenant entitled to a renewal lease in the first place?
The tenant is entitled to a renewal lease unless the landlord has good cause to not offer a renewal lease. And the landlord would have to bring a case in housing court. For instance, I thought of there are like 8 different reasons that are also in the rent stabilization law and code, like failure to pay rent, violating a substantial obligation of the tenancy, tenant commits a nuisance, tenant is occupying the apartment in violation of the law, tenant is using the apartment for an illegal purpose like dealing drugs, owner wants to use the apartment for his or her own purpose or because of an immediate family member of the owner needs to use the apartment, or landlord wishes to demolish the building and withdraw the building from the rental market. And another reason is the tenant has unreasonably refused access to the landlord. For instance, if the landlord wants to make repairs and the tenant won't let landlord in.
Now, on that, in any real situation, the landlord can't, continually demand to come into the apartment. They may have some basis just to make sure there's no damage or that things are in good working order.
Right. A landlord can't be asking to come in every day. A landlord can't be using landlord's key to come in. You know, landlord is allowed toward the end of a lease to show the apartment to prospective tenants, to new tenants. Landlord is allowed, if landlord's bank wants to inspect the building to issue a mortgage, or the tenant should give access for that reason. But landlord has to give proper notice about the need for access. I could do a whole program about access, actually.
Right. And the other thing is and this is true for any landlord-tenant situation. The landlord cannot exercise self-help, and the tenant cannot be told, get out of that apartment now or else, or I'm going to call the police. The landlord has to go to court to have a judge issue proper warrant or whatever it takes and go through the process, which the tenant can challenge before they have to move out of the apartment.
Unless in New York City, if someone has been occupying an apartment for less than 30 days, landlord can use self-help. I don't know of any landlord lawyer who would suggest to a landlord to use self-help under any circumstances.
And we want to recommend to let landlords know and let tenants know that a landlord cannot use self-help. They must go through the courts.
Right. If a tenant has a problem like that, tenant should go to the police if tenant has been locked out.
Exactly, and I guess that's the right word. Under no circumstances can the landlord unilaterally lock out the tenant.
Right. Now, this law, the good cause eviction law, applies only to certain landlords and tenants in the city of New York. The law also provides that other villages, towns, and cities in New York State may opt in. Unfortunately, I'm not prepared to tell you tonight, but I think some cities in New York State already have their own version of the good cause eviction law. I think Kingston has such a law, but I'm not prepared to tell you how many municipalities have such a law.
And obviously, a landlord should consult a knowledgeable attorney for their rights in dealing with tenant issues, and a tenant, regardless of their status, should consult with a lawyer if they can. Perhaps it's someone through legal aid or a pro bono attorney or a private attorney like yourself to see what their rights might be to challenge some type of eviction.
Certainly, and this law in particular is a very new law, and judges have to interpret it, and we'll see cases in the coming months and years. Now, listen, I have to tell you, this law doesn't apply to every tenant in the city of New York. It does not apply to rent-stabilized tenants, to rent-controlled tenants, or to tenants who are covered by the New York State loft law. It does not apply to tenants who are shareholders of a cooperative corporation. Of course, it doesn't apply to condo unit owners who are not tenants at all. And oddly, tenants with a very high rent are not covered by this law.
And when you say very high, how high is very high?
Very high rent is 245% of the fair market rent.
So
now
just an approximation, what are we talking about?
I don't know. What is the fair market rent? The New York State Division of Housing and Community Renewal has to define that term. I know that, for instance, if you go to DHPD's website, Department of Housing Preservation and Development, you Google fair market rent, they give you fair market rents by zip code, by studio, 1-bedroom, 2-bedroom, 3-bedroom apartments. but I don't know whether that's going to be what New York State Division of Housing and Community Renewal will decide. I don't know. So that's an open question at the moment.
Okay.
So I don't know how high is too high to be applied. Does the law apply to every building in the city of New York? No, it doesn't apply to buildings built after the year 2009. Does it apply to every landlord in the city of New York? No, it does not apply to small landlords.
And so obviously the law has different protections, but it has there are many situations it does not apply to. So a tenant, assuming they have a lot at stake in protecting their tenancy and their apartment, it's probably worthwhile if they consult with at least a knowledgeable attorney to see what options they have and what defenses they may have, whether they have to go to court or they're trying to negotiate a resolution of a landlord-tenant dispute with,
right.
with
it
a landlord.
Yes. It would be much better if the tenant, found out by through the investigation of an attorney hired by the tenant. It would be much better if the tenant found out that the tenant is rent stabilized. That's the gold standard. A rent stabilized tenant has a lot more protections than a tenant covered by the good cause eviction law.
And I'm going to ask you in a moment just to define the rent stabilized tenant, but I want to remind our listeners you're listening to Law You Should Know on 90.3 WHPC, the voice of Nassau Community College in Garden City, New York. And if you missed any portion of this program or any other show on Law You Should Know, you can go to the podcast at nccradio.org. We're talking with attorney Linda Rzesniowiecki, and she is an expert in landlord-tenant law, especially representing tenants and small landlords. And tonight we're talking about the good cause eviction law and how it provides additional protections for certain tenants.
Right. And I mentioned a small landlord. The law also defines what is a small landlord. A small landlord owns less than 10 housing accommodations in the state of New York, and that person is not covered. Also, if the building you live in is occupied by the owner lives on the top floor of a 3-story house, let's say, the building would not be covered by this law. So how do you find out what a landlord owns? There is a website. There is a something called ACRIS, ACRIS, which is an acronym. If you Google ACRIS, it'll take you to it's a site where you could look for all the deeds in the city of New York, and you could search the landlord's name and see what that landlord owns. That is, if the landlord owns the property in his individual name. If the building is owned by ABC Corporation, you could find out all the buildings that ABC Corporation owns. But there's a problem if the building is owned by a limited liability company, also called an LLC. It's pretty much impossible to figure out what individual is behind that LLC. There was a law proposed whereby, all the LLCs were obligated to reveal who the individuals are behind the LLC, but that law passed in a very limited way, so that LLCs have to file something with the state of New York, but that's not an open record that a tenant could access. So, there's a lot of research to be done to find out whether your landlord is a small landlord. That's interesting.
And you also mentioned earlier about a notice to cure. So if a tenant receives a notice to cure from a landlord, it's something they should not ignore. What if they think it's unreasonable, or they've tried a little bit to cure it and they think they've done enough? Or should they also consult a tenant attorney if their enjoyment of the unit is at stake?
Yeah. There are various kinds of notices that are given to a tenant prior to the commencement of the case in housing court. If a tenant hasn't paid rent, there'll be something called a rent demand served. If a tenant, if the landlord alleges, that is, that the tenant hasn't paid rent, there'll be a rent demand served. A notice to cure might be served if the tenant has a subtenant in possession of the apartment without the written consent of the landlord. That's a 10-day notice. And, the thing is not to be an ostrich. Don't hide your head in the sand if you get a notice. The time to call an attorney is when you get the notice, because there are very strict rules about how a notice should be served on the tenant and how the notice should be written. And if a landlord messed up in any way, then that notice might then the court case based on that notice will not survive. So we talked about notice to cure. If tenant does not cure on time, then there's something called a termination notice saying, hey, I sent you this notice to cure, you didn't cure. Now I'm terminating your lease. You have to get out by this day. I have heard stories about termination notices being served. This building is being sold, and therefore you have to get out by this day. Well, let me tell you something. That is not a proper ground for evicting a tenant. Not at all. Under the good cause eviction law, that is not one of the good causes. The new landlord is stuck with all the tenants who are in the building, unless the tenants have committed some violation of some kind.
So, and even at each stage, it can't hurt. The tenant may have rights to fight the proceedings. They should still consult a lawyer. If they missed the initial notice, they can still challenge the notice to whatever. And even if they're being ordered to vacate, they can still try to challenge that.
Oh, certainly. It makes me very sad when, a tenant calls me. I had a tenant call me recently to say, we got this notice that we have to vacate because there's a new owner, and I told you that's not a good reason. So we found a new place to live and we signed a new lease. But now we're thinking the old owner should pay us our moving expenses and our first month's rent in the new place. I said, I'm so sorry. It's too bad you didn't call me when you got that notice. Then you could have said, landlord, I'm not leaving unless you help me financially with my move.
And I just want to expand that a little bit. The tenants, all kinds of tenants, may have different protections under the law, but yet the landlord may have different reasons for wanting their space for themselves or for other tenants or for whatever reasons, that doesn't prohibit economics from the tenant providing some kind of incentive for the tenant to waive their rights or not exercise their rights and just move. And they can have, the tenant is welcome to have a lawyer negotiate the transaction.
That's right. And it often happens in housing court. There are many delays in housing court, and landlords know it.
And uncertainties too, and again, the tenants may have rights to delay or different defenses to make, but sometimes economics can help move things along, or a little grease helps the wheels turn.
Many landlords will offer some money in order not to wait a year or a year and a half for the tenant to move out.
And is the term kind of called key money? Money to expedite things and get the key.
Oh, key money is something else.
Okay.
Key money is what tenants give. Illegally, landlord might demand key money from the tenant in order to get the keys to an apartment.
I see.
That is not a legal practice.
Okay. I just want to remind our listeners that we're talking to Linda Rzesniowiecki. She's a landlord-tenant attorney, primarily representing tenants and small landlords. You're listening to Law You Should Know here on 90.3 WHPC, the voice of Nassau Community College in Garden City, New York. If you missed any portion of the program or you want to hear other shows from Law You Should Know, just go to the website, nccradio.org. Please keep in mind whatever you're listening to is presented as information only and is not intended to be legal advice. Whether you're a landlord or a tenant, you must consult your own knowledgeable attorney for legal advice applicable to your situation.
Yes, because the facts of your particular case matter a lot. So this is just general information. By the way, my website is www.landlordtenantlaw.net. And there's lots of information there, and my contact information is there.
And the field of landlord-tenant law is very complicated. The procedural rules in the landlord-tenant courts, especially those in New York City, are very complicated. Some self-help is available. Some legal services might be available to small landlords or tenants with limited means. But otherwise, it pays for a landlord, a small landlord, or a tenant, especially with enough at stake in terms of their rent, in terms of their housing situation, to hire an attorney or at least consult with one about what their options might be and how they can proceed.
Right. You might call, for instance, the New York City Bar Association Attorney Referral Service at 212-626-7373, Mondays through Fridays, 9 to 5, and they might be able to help connect you to a legal services provider in your area.
And there are, and other bar associations have inexpensive consultations with attorneys. There are also some civil legal aid organizations inside and outside the city that might offer certain groups of people free or low-cost legal services. Linda, what else would you like to mention? The other things tenants should be aware of and small landlords should be aware of about the good cause eviction law?
One thing I'd like to mention is the good cause eviction law disappointed tenants because, a 10% rent increase, for instance, is very high. Under the Rent Guidelines Board order, that's the current Rent Guidelines Board order, the rent increase allowable to rent-stabilized tenants for a one-year lease is only 3%. So this law is disappointing in the huge increases that it allows, as compared to being rent stabilized.
On the flip side, if the landlord has a good tenant, one who pays their rent, one who doesn't do anything, doesn't damage the apartment, one who gets along well with others, the landlord may want to take a little less as an increase because they're getting a good tenant who's following the rules and paying their rent. And you never know whether the next tenant's going to do that.
That happens. What I have found is when a landlord of the greatest generation, right, an 80-year-old, 90-year-old woman or man passes away, their sons or daughters, if the building stays in the family, might be a lot greedier and not have a personal relationship with the tenants and not care about what kind of increase they get. So, that's really a time to be very careful and aware of what's going on if you've had a landlord that you've enjoyed a good relationship with who then passes away.
On the flip side, if you're that tenant, though, you can try to enforce your rights for repairs, for improvements, concerning nuisances. You may have both gone along to get along. So there are, each side has different tools in their tool belt.
Right, exactly. Yes, that's true.
And Linda, give us your website again.
www.landlordtenantlaw.net. That's my website. So a kind of a long one, but
with a lot of helpful information as well to both small landlords and tenants. And even if you're going to court, usually the courts are not opposed to parties coming to some negotiation and some resolution of the matter, and maybe each side gives up a little. But even tenants and small landlords should have an attorney represent them so they understand what rights they're giving up and what benefits they're going to get through that negotiation.
That's true. 90 or even 95% of cases in housing court are settled in some manner. Most cases are settled. Oh, and by the way, small landlords do not get any free representation in the housing court.
Right.
Only tenants of limited means are entitled to free representation.
And again, we're just about done with our time, but again, it may be worthwhile for a tenant or a small landlord to hire an attorney to properly protect their rights. I'd like to thank everyone for listening, and please join us next week at this same time for another program on Law You Should Know.